question. And I think Corey hit on a couple things that are interesting about those resolutions, and that might be something, depending on, as the last panel talked about, what kind of chair we get next and what kind of enforcement director we get next, could be harbingers of what we're going to see maybe in the future. One good example is the clone order, the mutual fund ETF clone case that Corey talked about. It's a Reg BI violation that looks a lot like the share class selection disclosure initiative from the prior administration, where there are two products that hold identical portfolios and one's more expensive than the other. Here it's charged under Reg BI because it's a brokerage issue, but we have a self-report and we have no penalty, very similar to the type of thing that we saw back with the share class selection disclosure initiative. The other case that I think stands out, because we may see less of cases like this going forward, is there was a case about a preference for JP Morgan's internal portfolio management product versus a third-party product. The order suggests, maybe is explicit, that the internal product was cheaper than for investors than the third-party product. Nonetheless, the case got settled, and there was a $45 million penalty associated with it. No disgorgement, presumably because there was no client harm. I think a case like that might be less likely in a future administration, sort of regardless of who the chair is.